I understand a couple of people are actually in the room, though I'm not seeing them, and I'm just obligated to take note that we keep the 2-meter physical distancing. We wear non-medical masks and maintain proper hygiene. Before I ask for the two witnesses, Madame Grenier and Sandra Wesley, I just want to entertain a motion for those who, the subcommittee meeting, we arrived at 4 decisions. The report of the subcommittee has been circulated to members. Ask for a motion to adopt the subcommittee report. Those have somebody move. Pam moves. Any discussion? Seeing none. Those in favor? None opposed? Good, thank you very much. And won't go into any detail just because we are really running tight. So with that, I'll welcome Ms. Wesley and Ms. Grenier and ask you to speak in the order that you are listed in the order paper. So with that, now we are running very late, as you can see. So the overall hour is going to become 45 minutes. And I'm just going to arbitrarily take a minute off everybody's time. So I apologize to the witnesses because I know it's difficult to get here, but we are dealing with the realities of virtual parliamentary procedures. So with that, Madame Grenier, if I could ask you for 6 minutes, please.
Oui, bonjour. Merci de l'invitation.
Yes, hello. Thank you for inviting me. I would like to introduce the organization that I represent, the Projet Intervention Prostitution Québec, Inc. And it works on sexual exploitation and sex work. We work in prevention of sex work for young people, for youth. So we offer training in schools and in youth centers where we can work on protective factors, self-knowledge, healthy relationships, etc. And we do outreach work in the field, street work, with reaching people who are not affiliated with institutions, accompaniment according to the needs, administrative procedures. We do outreach work with, for example, massage parlors, including the one where Marilyn Levesque worked. We also work in collaboration with other community agencies, schools, health and social services, but also with prosecutors, police, researchers, and this allows us to ensure a better coherence of resources and services, but also to share our expertise and take a look at the phenomenon completely. We also have a neutral position, so we are devoid of ideology on prostitution. We consider that there is a spectrum from exploitation to full consent, and that all the realities from one end of the spectrum to the other exist, and this is up to the person living the situation to name his or her reality, and we help them according to this. If they want to leave prostitution, we accompany them. If they want to practice, we ensure that they can do it as safely as possible. We respect these different realities, and that's why we take a position for decriminalization of prostitution. It's a bit in this sense that I've taken steps to be heard, because it is essential to me, in the case of the murder of Marilyn Levesque, to push reflection beyond what happened. This case was received a lot of media attention. She was blonde with blue eyes, and there was a murderer. But there are so many murders of sex workers in Canada, Aboriginal people, racialized, trans, and poor women who do not receive the same attention and for whom we perhaps do not bother to look for those responsible. But that tells us that there are other factors that need to be assessed. And one of those factors is the law that regulates prostitution, because it is clear that the current law does not fulfill its objective of protection. So, the Protection of Sexually Exploited Persons and Communities Act. It has an ideology, and its goal maintains stigma by implying that sex work is necessarily wrong, that it is shameful, that it should be hidden. But stigma is a direct cause of the danger that comes with sex work, because the work itself if the stigma is removed, is not intrinsically dangerous. But this stigma can make it dangerous because you don't necessarily tell your family and friends as much. They don't know where you are, what you're doing. People see sex workers more as objects than women, so it creates a kind of social acceptability of violence against them. And it can also hinder attempts to reintegrate into the labor market, etc. The law implies that it is impossible to engage in sex work without being exploited, which is a big value judgment. If we go back to the spectrum that I mentioned, if our laws, policies, the variety of programs funded deny a whole section of what is a reality regardless of our personal values, it is a failure because we're abandoning part of the affected population because we would rather turn a blind eye and believe that it doesn't exist. And we put a value judgment that reassures us before the safety of people. There are two particularly problematic aspects of this act. So, criminalization of customers. Firstly, it did not stop or reduce demand, and it put sex workers at risk because frightened clients will often take them to isolated locations where help is unavailable, making it harder to escape when needed. It prevents them from taking the time to sort clients. For example, if they get into a car and the client is in a hurry, then they don't get to sort them. Also, the law is not often applied. In Quebec, for example, only 233 clients have been charged since 2014, not even 40 per year. So we can't say that there's a positive impact. All this does is prevent sex workers from increasing their protective factors. And it's the same for criminalization of third parties in sex work. This is one of the aspects of the law that was declared unconstitutional by an Ontario judge in 2020, less than a year ago. There was a study published last Thursday by Dr. Anne-Louise Crago of the University of British Columbia, which tells us that tells us who sex workers turn to when they're in danger. More than 30% of the more than 40% of sex workers questioned, they said that they would turn towards other sex workers or people in the industry like security guards, managers of establishments. And so if they're in the presence of these people who are considered criminals by the law, they feel they are the safest. If Marilyn could have received her client at the salon with a third person as a lookout, then she wouldn't have received those 30 stab wounds. There wouldn't have been enough time. Also, the protection of these third parties is in turn one of the reasons why, according to the same study, only 5% of sex workers turn to the police in case of danger. Criminalization of third parties therefore forces sex workers to choose between foregoing police protection in an emergency or putting themselves, their colleagues, or their bosses in legal jeopardy. So violent clients are not reported by sex workers or facility operators for fear of closure, arrest, or job loss. Madame Gagné.
6 minutes at this point, and I apologize for that, but we are under some pressure for time. So if you could wind up your remarks, I'd appreciate it. Is that good? Okay, I apologize for that. And I'll say that to Madame Wesley that maybe just take a look at the chair when from time to time, and I'll give you some indication how much time is left. So with that, Madame Wesley. You need to take, that's it.
Oui.
Okay.
Bonjour.
Hello. I was going to speak in French, but because I have a limited time, I'll speak in English in order to be able to speak more quickly in my remarks.
Of Stella Lamy de Mamie. We're an organization by and for sex workers. We were founded in Montreal 25 years ago. Every year, we make on average between 5,000 and 8,000 contacts with sex workers here in Montreal. We are fully by and for sex workers, meaning that our staff, our board, our members, we are sex workers ourselves. We represent and are accountable to our community. So as you probably know, in in the Bedford case at the Supreme Court, criminalization of sex work was declared unconstitutional on the basis that it violated our rights to health and safety. That right to safety that the Supreme Court talked about is precisely the right to not be murdered, the way Marie-Hélène Lévesque was. The response of the government at the time was to fully criminalize sex work for the first time in the history of Canada and create a set of laws that does not aim to protect us, that does not aim to improve our working conditions, that does not aim to make sure we can screen clients appropriately. The only objective of this law is to eradicate sex workers from Canada. So when we have a government that chooses as an objective the elimination of sex workers, we cannot be surprised when aggressors choose to be violent towards us and take up that call to eradicate sex workers from Canada. It's pretty rare that Parliament cares about sex workers and invites us to speak. And we know that there has been no such committee for the dozens of other sex workers who've been murdered since this change in the law. So specifically in the case of Marie-Hélène Lévesque, there are many parts of this story that are very clearly tied to the criminalization of sex work. We can look at the fact that this man had been a client of a massage parlor on several occasions and had been banned from that massage parlor because he was violent. It was impossible for that massage parlor at the time to call the police or to call the parole board because sex work is criminalized, and calling the police on a violent client usually means maybe people getting arrested, people losing their source of income, attracting more police repression to our workspaces. So as sex workers, it's not possible for us to do that. If they had been able to contact the police or the parole officer when he first acted violently toward a sex worker, he would have been sent back to prison and would not have had the opportunity to escalate his violence and murder Marie-Hélène Lévesque. We also know that hotels have been targeted by police repression when it comes to sex work. In the summer of 2019, police forces across Quebec launched operations called Radar, encouraging hotels and other tourism businesses to detect sex workers and to report us to police under the guise of potentially protecting us from exploitation. So we know that when Marie-Hélène Lévesque walked into that hotel on that night, she was preoccupied with making sure she was not detected as a sex worker. She could not tell the receptionist, "Oh, I'm seeing a client. If you don't see me in an hour or two, do you want to check on me?" She could not make any arrangements for her protection because that would have led to being detected, being kicked out of the hotel, and possibly arrested or have her money seized. We also know as sex workers that when we're victims of violence, when a situation is scary with a client, that we might not scream. We might try to de-escalate on our own because we know that if we make a scene in a space like a hotel, we will face the consequences of the criminalization of sex work. So it's very clear that the laws that we have in place, criminal laws against sex work, put Marie-Hélène Lévesque in a position where she was not able to screen her clients. No client will agree to give IDs and go through a background check before booking an appointment in a context where he can be arrested for buying sex. We also see in the reaction to this murder that the response from Corrections Canada and the Parole Board have been mostly to say that they're against the purchase of sex, period. So once again, we're focusing on sex work as the harm instead of the actual violence that someone has experienced. Since I don't have a lot of time, I think one important point I want to make is that this is not a tragedy. This is not irrational or hard to predict. This is the direct effect of the decision that the government has made in 2014 to criminalize sex work. And it is the continued impact, and it is to be expected. More sex workers will be murdered if we keep these laws. The only recommendation that this committee needs to start with is the full decriminalization of sex work. I represent thousands of women. A lot of us have been victims of violence. A lot of us could have been Marie-Hélène Lévesque. And we know for a fact that if Marie-Hélène Lévesque was sitting in front of you today, fighting for her rights to work safely, you would be dismissing her the same way you've been dismissing sex workers for over 40 years and refusing to give us the rights that we should have. So I encourage you to make sure that the work of this committee leads to actually respecting sex workers, understanding that we will continue to exist and continue to work and give up this foolish and problematic quest to eradicate us from Canada. We need to be talking about our rights as workers. We need to be making sure that we don't just pass the blame to the Parole Board and Corrections Services Canada, because this murder could have happened in many cases with no involvement from Corrections Canada, the same way that many sex workers have been murdered in the past few years. I would even add that the same night that Marie-Hélène Lévesque was murdered in Quebec City, another young sex worker was murdered in Montreal, and no one has been talking about her death, and there hasn't even been a proper investigation. And that is the reality of all marginalized sex workers across Canada. We die, we hold vigils for ourselves, we try to be resilient, but Parliament maintains the position that we should be criminalized.
Thank you, Ms. Wesley. It's 5 minutes, please.
Thank you, Chair, and thank you to the witnesses for being here today. Ms. Grenier, I'd like to ask you, it appears that the government is very reluctant to make this full report public. Did your organization ask to see the report, and would your organization be interested in seeing the full report?
C'est sûr que ça nous...
Yes, we would be interested in reading the report. But as we said, this is just one aspect. It is more important for us to keep talking about decriminalization.
The review of the board's decision to release this offender, despite his violent history, put people at risk. While it's easy to say in hindsight, but experts that I've heard from, including former parole board members, have said that there's no way this offender should have been placed back out on parole before a thorough review of those risks. That should have included a review of the risks to the facility he had been frequenting, including the women that he had, the women that were there. Do you think it reasonable, Ms. Grenier, that corrections and the parole board should try to determine if the offender had been violent prior to his day parole being renewed?
It's hard to say. I only know what the newspapers say, but I know that the information in the media and newspapers is not necessarily true. I think that anyone who has perpetrated a crime should have their risks properly assessed.
That?
Sure.
So I took the time to read the parole board decision. I've also read everything I could find in terms of the report on this situation. And it seems very, very, very clear in this case that this man was not given proper rehabilitation services for the whole time he was incarcerated, and that the evaluation of his risk to reoffend was not done in any serious way. Most of the things that the decision was based on were his behavior with other prisoners in prison. And we know that men who are violent towards women and only towards women and only in intimate settings and sexual settings tend to be very well behaved around other men. And that's not in any way an indicator of their risk to reoffend. It seems pretty clear that this man was a particularly high risk, and that was considered acceptable to put sex workers in that position to face that risk, while other women were not considered to be good candidates to be around this man.
Well, that leads into my next question is, do you believe that the parole board or correction services took into consideration the actual threat to sex workers from this offender when they recommended this individual who had a history of violence against women engage in procuring sex and, or in the subsequent actions and decisions that they made? So obviously, Ms. Wesley, you feel they have not. Ms. Grenier?
Point of order, Chair. The parole board did not say that this man could solicit sex work. So I just want to correct the record on that.
Well, what the parole board did do is they allowed him parole knowing that was what was going to happen. So they have the final authority on parole. Mr. Chair,
they didn't authorize
Mr. Chair, if my
though,
time
Chair.
could stop in enough time, please.
Your time has stopped. I do think that you are probably asking questions that may be a little bit beyond the expertise of these two witnesses, and more and better directed to people who are familiar with parole board and the prison services. But I'm going to allow the questions under the circumstances, and that the witnesses just be asked to comment within their realm of knowledge, as opposed to realm of speculation or hearsay. So with that, I'm going to allow Mr. Motz to continue.
Thank you, Chair. It would appear that that no one warned the massage parlor that this offender frequented that he was a threat to the workers there. Do you feel, given both of your the work that you do and the background that you have in helping individuals, that this is something that should have happened, that this facility should have been warned, being they knew he was frequenting one place? Should they not have been told that this person had this history and he was a threat to the people that work there, especially the women?
Yes, absolutely. They should have been notified. But once again, sex work is fully criminalized in Canada. That creates a huge barrier to sex workers being part of receiving that information, being treated with dignity and respect. And we see in the reaction now from Corrections Canada and the Parole Board to have this blanket statement about no former incarcerated person should buy sex. We're seeing that there's no intention on actually addressing how sex workers can be warned and can be partners in our own safety. It seems to me that the parole board's decision was not in any way based in any consideration whatsoever for the lives of sex workers. If anything, the objections that the parole board seemed to have about this man purchasing sex were rooted in a general sense that sex work is wrong, and not a sense that that sex workers are women who could be put in danger if they interact with him.
Thank you for that.
Thank you, Mr. Motz.
Merci. Alors, je demanderai maintenant à Madame Cara ou Monsieur Lightbound, l'une ou l'autre, l'un ou l'autre. Ça sera moi. Merci, Monsieur le Président. Merci. Alors, bon, il y a des sons de respiration et je dois dire que j'entends...
Okay, let's try this again and see whether we can stay with one language. Okay, go ahead.
Yes, thank you, Chair, and thank you to our witnesses for being here and for all the work that you do. Before I begin, I also just want to once again give my sympathies to Ms. Levesque and her family and her loved ones. My question is to both of you. Ms. Garnier and Ms. Besley, Stats Can reported there were approximately 294 homicides of sex workers in Canada from 1991 to 2014. We heard from Correctional Services that it does not condone offenders seeking sexual services or strategies, and that there are no other similar cases to the one that took place. We also heard from Parole Board of Canada stating that 99.9% of those on day parole do not reoffend violently. Given the laws that you spoke about, particularly for sex workers, is it possible that these incidents are not reported because there may be legal repercussions for sex workers?
Yes, absolutely. So we know that sex workers do not report most instances of violence to police. At Stella, we have a bad client and aggressor list that we've been running for 25 years, where sex workers report to us incidents of violence so that we can share that information in the community and protect ourselves. And we know that since the change of law in 2014, it's even harder to denounce anything to police. And we know that police won't necessarily help. I think it's also important to point out that in terms of women who are incarcerated, a large proportion of incarcerated women are sex workers, former sex workers, or future sex workers. And we're very concerned about this general anti-sex work sentiment that's coming out of the investigations into this murder and the effects that they will have on women who are also coming out on parole and might be punished also if they engaged in sex work, if there's this big anti-sex work attitude. And as you've said, the vast majority of offenders are not violent and are not a threat to sex workers. This man was a threat to sex workers, not because he liked to purchase sex, but because he was a violent man who targeted women in a very specific way. As sex workers, we need clients. We like good clients. And any attempt to restrict good clients from accessing our services only puts us in a situation where we have fewer good clients, more need for money, and we end up having to make compromises on our health and safety.
Thank you, Ms. Grenier, if you want to add.
Oui, ben, j'irais vraiment dans le même sens, effectivement. Là, pour répondre.
I'd go in the same direction. The figures are quite clear because it's not denounced, and also because there are homicides that we don't necessarily link to sex workers, even though there is a relation. And maybe going back to somewhat to the previous question, but to prevent all offenders to purchase sex service. I mean, I think for him it was a very specific issue of violence, as Sandra mentioned. And, what we are repeating is that even if the massage parlor had received prior information, because they don't have any relationship with the police, because it might be dangerous for them, it might be leading to loss of employment for the girls who work there or closure. Well, that's the problem. Even if they had received prior information, what would they have done? And we also know that during the day, he went to that man went to another massage parlor in the south of Quebec where nothing happened.
Bit about suggestions on how criminal justice system, and I know you talked about decriminalization, and I know the Department of Justice has a mandate to review the law, but can you perhaps suggest how correctional services and Parole Board of Canada systems could be improved to specifically protect the lives and safety of sex workers who may be put at risk by violent offenders?
You have about 30 seconds, please.
Well, I would say that as long as the government of Canada has as an objective the eradication of sex workers from Canada, it's really hard to think of anything that can be done in any government institution to protect us. The government needs to instead have an objective to give us good working conditions and to protect our safety. Once that is in place, laws and policies can follow. But right now, in a context where buying sex, selling sex, and everything around it is a criminal act, it's hard to think what Corrections Canada can do to address that other than simply having respect for us as human beings.
Thank you, Madame Cara. Madame Michaud, 5 minutes, s'il vous plaît.
Merci, Monsieur.
Ms. Michaud, 5 minutes. Thank you, Mr. Chair. Thank you to the witnesses for your presence. It's very much appreciated. I'll start with Ms. Grenier. You said at the beginning of your speech that Marilyn Lévesque's case was big in the media because she was a blonde and with blue eyes, which is probably unfortunately true, but also because there are government institutions that made serious mistakes. And that's why we're looking into the issue, be it the Parole Board or CSC. There were mistakes done in that case. And I think it is necessary that whatever the case, that parliamentarians also look into the drama that sex workers are facing. But in that specific case, and I'd like to come back to the question that my colleague, Mr. Motz, asked previously. You're saying that no, the massage parlor or in general, case management teams, even if they're informed, are not informing the massage parlors because they're afraid of police actions. But how could we... what I'm trying to understand is it common, this type of things that sex workers are seen by people who are in day parole or on conditional release? Do you have this type of information? And you also mentioned that it might be possible that third persons accompany these women. So how would that work in that case? So I'd like, to hear if you have anything to say on that. Well, Ms. Wesley, might certainly have something to add to what I'll be saying. It's not that correctional services should not inform the massage parlors, but the massage parlors would not have resources, even if they would receive that information that someone, was at risk of coming into their institution, because they would not turn to the police because that's dangerous for them. So what we need is to give the women themselves the right to choose how they want to protect themselves. So we can imagine many things, women organizing amongst themselves, because very often we have, the image of these violent men, and that it's violence against women. It doesn't need, some women do organize and offer sexual services because they want that. They might hire someone who protects them, and they share, the revenues and the fees, and they are, of course, entitled to say no to some clients. So they choose for themselves, and they're entitled also to establish their working conditions, because, when you're working for someone else, you might not be able to decide about your conditions. So these are all possible ways to improve the conditions. What's important is that it comes from the women themselves. Maybe before Ms. Wesley responds, I have another question that comes to mind on that. If she had known, for example, that this man had a history of sexual violence against women, or, violence against women, maybe, she would have refused to take him on as a client. So this is where I have questions, because that is an information that the case management team of Mr. Galley had. Should that information be given to the massage parlor? And then maybe Marilyn might have refused to see that client. Yes, I think that transmitting information can always only be useful, but it's certainly not a miracle cure. Well, to respond to your question, to your many questions actually, with regard to third parties, any person who helps us, if I work with a friend, for example, a pimp, any person who contributes to our work is considered to be a pimp. And even if these persons don't make any money, it's still another criminal act that is, even if there's no money exchange. So these third persons very much often help us. So, there are all kinds of safety measures and creating this relationship with the violent offender. If they see that we're protected, if they see that there is someone who takes care of us. In the case of Marilyn Lévesque, I think that the gentleman was very aware that it was important for Marilyn Lévesque not to be detected by the hotel and not to be seen as a sex worker. So we might, imagine a situation, if she was undressed, would she have gone outside of her room? I mean, all of these things play. Now, with regard to the number of ex-inmates that are in contact with sex workers, we don't have any statistics on that. However, people from all spheres of societies go to sex workers for all types of reasons. So they're parliamentarians and ex-inmates, people who work in the various environments, who use sexual services in different settings, which are not necessarily settings of violence or exploitation.
Madame Michaud, Mr. Harris, 5 minutes, please.
Thank you, Chair. And I want to thank both of the witnesses for your very important evidence, because I think we haven't heard that perspective before this committee on this issue. Clearly it seems to some extent we may be barking up the wrong tree when it comes to the kind of questioning we've been placing before the CSC and the parole board, for example. And I think it's good that to hear that there is a point of view that we haven't considered in this context. So thank you very much for your presentations, both of you. Let me ask you, I know it may be very difficult to answer from your point of view, but Miss Wesley, I guess, and Miss Grenier, is there anything that the parole board or the CSC should have done differently? As was pointed out, mistakes were made, decisions were made that led to this very unfortunate consequence for Ms. Levesque, and there is some blame clearly to be placed on the CSC and the parole board for their actions. Was there something that you could suggest that could have been done differently or should have been done that may have prevented this death?
Yes, there are many things. I think the first mistakes in this case date to the very first time this man was ever arrested for violence against women, and every time after that, where from what we've seen from the record, he's been essentially warehoused in a prison for 15 years and then let out without any meaningful rehabilitation. We don't believe in a punitive carceral approach. We believe in serious, meaningful rehabilitation and finding ways to make sure that if someone has been incarcerated, that the day they come out, they are in a different position. And when it comes to violence against women, it's an area that is particularly mistreated in the criminal justice system at every step. We are in solidarity with a lot of the demands of women who experience intimate partner violence in terms of the criminal justice system simply not being able to address that. A lot of men are violent towards women and only towards women, and that's not addressed. So we're glad that there will be training on intimate partner violence. However, it doesn't address the case here of Marie-Hélène Levesque, who was a sex worker who was murdered at work, so not in the context of an intimate partner relationship, and we think that that should be included. When I've heard about this training, my first thought was that obviously, once again, they will talk about us without ever consulting us regarding what should be said in that training and how that should be implemented. And I think it goes beyond training. It goes, we need actual policy changes. We need to review why we incarcerate people and what we do with them while they're incarcerated, and how we identify those that can't be rehabilitated and what conditions we can put on them. I'm quite concerned that one of the outcomes of this will be to make it harder for inmates to get out on parole, knowing that a majority of people trying to get parole are in prison because of poverty, because of colonialism, because of racism. We know that Indigenous people are overrepresented, Black people are overrepresented, and is the outcome going to be that the actions of this one white man will lead to more problematic incarceration of Black and Indigenous people? We're quite concerned about that. We need meaningful reform, not simply training and statements against the sex industry.
Thank you for that very fulsome response. Yes, programs in the prisons themselves. We all know that the prisoners eventually will get out, and when they get out, they need to be. It needs to be a safe place that for people when they do get out, and that involves programming that is often absent. Ms. Grenier, would you like to add anything to in response to my question?
Non, Madame.
No, I think everything that I had to say was already said. As you say, there needs to be a specific focus on sex workers, and beyond training,
that was talked about in our committee was training for the correctional officers, not what happens to the prisoners inside the prison. And is there anything that are you of the belief that there can be effective programming for people like this in prison?
Oh, not for employees. Okay. I think that you need a lot of work for training, and you need training for parole officers and correctional services officers, and I've lost my train of thought, but we have to go beyond training. You have to look at the person who allowed this person to receive services from a sex worker. So there needs to be a global culture change.
Mr. Harris. Yeah. Colleagues, we've gone with some discipline with the witnesses and ourselves. I'd anticipated ending this meeting at 5. I think I could squeeze in another round of 2-minute questions if that's of interest to colleagues. Is that of interest? Okay, so if I could Could I have a conservative questioner for 2 minutes, please?
I believe I'm on next, Mr. Chair.
Okay, thank you, Mr. Van Bopta.
So,
2 minutes.
2 minutes. I'll try to keep to that. Thank you so much to both witnesses for coming here and sharing your wisdom and professionalism. So thank you for that. I also want to just reflect on how difficult this must be for the friends and family of Ms. Levesque and for all sex trade workers who are murdered, which is terrible statistics in Canada. And in retrospect, it all seems so obvious when we look at the reports that Mr. Galiz was a dangerous man and should not have been allowed to go unsupervised with Ms. Levesque. The Board of Inquiry found that there were many pre-incident indicators in this man's life that indicated that he was dangerous. And I know that, Ms. Wesley, maybe this is a question for you. You're saying it's not helpful to blame everything on the Parole Board or Corrections Services Canada, but do you find any blame on them at all? They could have prevented this.
They could have prevented it to a certain extent. I think this case is such a clear-cut example of someone who should never been allowed to be anywhere near women. But it could have been a case that's not so clear-cut, and it could have been someone who's not particularly violent towards women. And I think it's important to make a distinction between they made a mistake allowing this specific man to be around sex workers. They also made a mistake in assuming that all sex work is wrong, and their objections to him seeing sex workers and the objections that still seem to be talked about in terms of why he shouldn't see sex workers is that sex work itself is wrong and no delinquent should ever see a sex worker, and that's also a big mistake that was made.
So fair enough. I only have a very short period of time. I would love to hear an answer from our other witness to that same question.
Well,
is there any blame at all to be placed?
Well, unfortunately, if we're going to get through our 10 minutes in 10 minutes, we're going to have to not allow our answer to come. With that, Mr. Lightbound, 2 minutes, please.
Oui, merci aux deux témoins pour vos présentations.
Thank you to both witnesses for your presentations. Thank you for the work that you do. It is very important. It is very clear in the report that in Mr. Galiz's situation, he should not have been able to go to the massage parlor. And I understand as well that you are looking for policy change. And regarding this, I would like to know what you think of Bill C-36 that criminalized the purchase of sexual services. This act was adopted about 6 or 7 years ago, I believe. What were the consequences of this? Answer. It doesn't only criminalize the purchase of sexual services, it also includes the services themselves. So not only on clients, but it's also a problem for sex workers. But what we see very clearly in our community is that this puts us at risk of HIV. Decriminalizing sex work in Canada would decrease this by 33%. It puts us in a situation that it's even harder to report violence. It's harder to have access to protection. There's a lot of repression against sex workers. There are a lot of extreme cases of police officers, 20, 30 of them, who arrive to catalog our tattoos, our piercings, telling us that they'll be able to identify our bodies when we're found dead, because that's part of their mandate to convince us to stop working in the sex industry. There's also the overdose crisis that is facilitated by the criminalization of sex work, and regarding Indigenous women, criminalizing sex work was also increasing vulnerabilities. These women are the most at risk of being arrested and having violent contacts with police.
With that, Madame Michaud, 1 minute, please.
Merci, Monsieur le Président. Je vais faire ça rapidement.
I'll be quick. You said it earlier that Madame Levesque is not an isolated case. There are a lot of victims of violence in the past few years. And my question is similar to Mr. Lightbound's. We know that that Canadian laws force women to work in isolated situations. Decriminalizing sex work, what changes could we make in order to expose women to violence, to limit their exposure to violence? About 3 years ago, we published this report, and I sent this to your clerk. So there was a consultation with sex workers throughout Canada. 30 groups represented these sex workers, and we have very detailed recommendations that could be used as a draft for a bill. We want total decriminalization. We want it to be removed from the criminal code, all mention of sex work, so that we have access to labor standards and other protections as workers. And when there are cases of violence, other parts of the criminal code can be applied. And we have other recommendations regarding provinces.
Guys, for interrupting people again, but I'm running this clock on kind of hard so that we can get through to our next set of witnesses. Mr. Harris, 1 minute, please.
Thank you, Chair. And Ms. Worsley, I want to ask you one question concerning Bill C-36, and I speak as someone who voted against that when it was before the House in 2014. Is there any way that a complaint, for example, to your organization from the massage parlor identifying Mr. Gillies as a threat to women could have worked? Say, is there any way under that legislation that could have been reported or somehow without endangering the circumstances and the vulnerability of Ms. Levesque and the others who worked in that parlor?
So we only receive reports from sex workers and disseminate them to other sex workers. We don't go to police because most sex workers don't. And in the current context, even if that massage parlor had contacted the cops, the likelihood of it being taken seriously and any meaningful action being taken are pretty slim. The law, because it's so hostile to sex workers and the attitude of police is so hostile to sex workers, usually we're received with nothing but contempt and dismissive attitudes from police. But obviously what we aim for in a decriminalized context would be to be able to report those things. And we work very, very hard in organizations like mine to try to accompany women who want to press charges, who want to denounce violence to police. And we see that it's pretty rare that any serious action is taken from police.
Okay, thank you, Mr. Harris. Who is the next conservative questioner? 2 minutes. Mr. Kirk?
Thank you very much, Mr. Chair, and I'd like to thank our two witnesses for joining us today. I would like to continue on with the question Mr. Van Popta asked regarding blaming the Parole Board and Correctional Service Canada to Ms. Grenier. You didn't have a chance to reply before, so I'd ask.
Madame Grenier? Mr. Kirk was directing his question to you.
Oui, pouvez-vous me répéter la question?
Can you repeat the question, please?
Sure, and if Mr. Clerk, if I could, or Mr. Chair, if I could have just an extra few moments of time. Ms. Grenier, I wanted to give you the opportunity to answer Mr. Van Popta's question about whether or not the Parole Board, and I'd extend Correctional Service Canada, is that the blame attributed that they would have some of the responsibility for this terrible tragedy.
À blâmer,
I think that whether they need to be blamed for this, it's a little strong, but they certainly made mistakes by allowing him to think that he could go there. But indeed, this person shouldn't have been allowed to frequent that kind of institution, but there are a lot of other things that need to be done in order to ensure the security of sex workers. So they're not the only ones to bear the blame for this.
Mr. Mr. Chair, how much time do I have left?
Well, you had 6 seconds, but because I'm a nice guy, I was going to give you another 40 seconds. But do you have another question?
Sure. To Ms. Wesley, observers of the justice system have criticized, in particular, the judicial and correctional system. Is this an example of rehabilitation at all costs? The circumstances that led to this tragedy.
I would say it's the complete opposite of that. There has been absolutely no evidence of any rehabilitation in this case. I know that there seems to be a desire to turn the death of the sex worker into some sort of indictment of the criminal justice system to try to have a more repressive and punitive approach, but sex workers do not stand for that. We are against carceral and punitive approaches, even for the people who commit acts of violence against us. We believe in rehabilitation, not at all costs, but in a meaningful, intelligent, dedicated way. To minimize incarceration and to eventually get to a point where we drastically reduce the number of crimes that are committed, the amount of violence that exists in our community. And we know that punishment is not the solution. So please do not use our debts and the violence that we experience to push an agenda to further incarcerate us and our community.
Thank you. Final 2 minutes to whom in the Liberal?
I'm taking it, Chair.
Oh, Madame Damoff, 2 minutes, please.
Thank you. And thank you to both our witnesses for this testimony. And I think we should be clear that notifying the massage parlor is not the answer. He should never have been allowed and never was supposed to have been allowed to go there in the first place. But my questions I want to direct to you, Ms. Wesley, because I really appreciate what you were talking about in terms of sex workers and the restrictions that have been put in place on them. One of the things that got changed during the Conservative era in corrections was the type of programming that was offered in prisons. And I'm you know, if we expect people to get out of prison and be able to function in society, I'm wondering, first of all, if you think that that's a really important thing that corrections needs to look at. And second of all, have you ever been consulted on that type of thing? And would you be interested in being consulted if they were to start to enhance their programming?
We would absolutely be interested in being consulted. At Stella, we've been working in prison with incarcerated women since the beginning of our organization in the 90s. And we see firsthand the overrepresentation of marginalized people and the lack of meaningful rehabilitation. And this applies to everyone. It applies to violent offenders, including violent women that we support. And it applies also to nonviolent people who are there for reasons of poverty. Most people come out of prison worse off than they were before going in, and that's a really big problem. So we would be very interested in being consulted in programming and policies and everything that can be put in place so that by the time people come out of prison, they're able to lead a healthier life and to not be a danger to other people, but also to find some sort of peace and happiness.
I think we should.
My time, Chair.
Yeah, you ran the clock perfectly, Madame Damoff. I want to, on behalf of the committee, thank both of you for coming. Again, I apologize for rushing this, but we are in a pandemic and we are in a virtual parliament, and the virtual parliament doesn't necessarily operate as efficiently as the real parliament. But nevertheless, I want to thank you for your time. And with that, we'll suspend while we re-empanel for the second group of witnesses. Meeting is suspended. So. that we finish by 5:45 because other members have meetings immediately beyond this. I don't have, just to the clerk and to members, I don't have the list of questions, and if that could be texted to me, questioners, sorry, if that could be texted me before the questions started, that would be helpful. But I did want to welcome the witnesses and start with Mr. Henry and I apologize, Mr. Henry, I'm going to cut you back from 7 minutes to 6, and same with Mr. Oh, sorry, not yeah, and same with Mr. Stapleton or Mr. Neufeld, whoever is going to occupy the 6 minutes. So and we'll cut back questioners by a minute each as well. So the other thing I just say to the witnesses, if you're going to have around the 4-minute mark, take a look at the screen, and I'll try to give you an indication of how much time you've got left. So with that, Mr. Henry, you have 6 minutes, please.
Alors, bonjour à tous, mon nom est David Henry, je suis le...
Hello everyone, my name is David Henry. I am the Director General of the Association des services de réhabilitation sociale du Québec. It is a group of 68 nonprofit community organizations working in the fields of social and community reintegration of adults in the justice system. The ASRSQ promotes community action in criminal justice and supports the work of its members. ASRSQ member organizations provide services to more than 35,000 people in the justice system each year in Quebec. Almost all of the halfway houses in Quebec.
Sorry. I appreciate that I cut back your time, and I don't know whether you speak this quickly, but we have an interpreter on the other end of the line converting into English, and I'm afraid that around 3 minutes she'll fall over from a dead faint because she can't keep up with you. So if you just slow down a bit, then the interpreters can keep up with you. Thank you.
Bien sûr. Donc,
So, the member organizations assist us, and we also include organizations specialized in employability, others that manage compensatory work programs, specialized services in mental health, addiction, women in the justice system, restorative justice, services for the families of incarcerated persons, advocacy services, etc. The cornerstone of the action of the Association des services de réhabilitation sociale du Québec is based on citizens taking on the responsibility for the problem of delinquency, including offenders. The ASRSQ believes that the active participation of the community in resolving problems related to delinquency contributes to social development and to the well-being of our community. Solutions must be fair and satisfactory to the victim, the society, and the offender. Halfway houses are organizations that serve as a pied-à-terre in a community for people in the justice system who are in the process of social reintegration and who are part of a gradual release process. Halfway houses allow individuals to meet their basic needs. They can then pursue their social reintegration process, including job search and personal development. They offer programs that vary from one agency to another: addiction, anger management, domestic violence, sexual delinquency, social skills, etc. Maison Pain Chaud, for example, offers a dozen programs to its residents. There are 3 types of halfway houses in Quebec: CCCs, Community Correctional Centers, which are managed by the Correctional Service of Canada, CRCs, Community Residential Centers, and CHCs, Community Housing Centers. The ASRSQ includes only CRCs and CHCs. The CRCs are the classic halfway house. They are managed by volunteers from the community. Halfway houses choose their residents. There's an assessment process to see whether or not the CRC will accompany and mentor the individual in the community. I want to make it clear that the ASRSQ has no power over these members. The member organizations are autonomous community organizations managed by their own boards of directors. The ASRSQ is not involved in the day-to-day operations of its members. nor should ASRSQ be seen as a union. We are a group of organizations. As a consultative body, the ASRSQ is involved in various working committees with the various correctional services. All CRCs, CHCs in Quebec are accredited by the federal and provincial correctional services in a compliance process. The compliance standards define all administrative and operational aspects of halfway houses in Quebec and complement the contractual agreements that are signed between the community organizations and the Correctional Service of Canada. These standards define the organization of services, the qualifications of community workers, the programs offered by the halfway house, the admissions process, etc. The success of transition houses in terms of social reintegration is undeniable, and a study conducted in 2014 by a student from the School of Criminology of the Université de Montréal establishes the recidivism rate at 1.25% during the course of this day. I invite the members of the committee who wish to do so to come and visit a halfway house. There is one in Gatineau, not far from Parliament. I undertake to organize this visit as soon as the sanitary conditions allow it and at your request. I'm going to allow myself a little historical reminder to help you understand why and how the principles of what is called direct supervision were put in place in Quebec. Historically, the Sauvé report from 1977 reminds us that community organizations were the first to set up structures for supervising people on parole in Canada. So, from the Archambault report and the Photo report, the federal government created the National Parole Service, an organization that reported directly to the National Parole Board. With the establishment of this organization, the intention was to make these supervision activities available across Canada. Nevertheless, this did not prevent the system from still relying heavily on the services of community-based organizations that were then known as post agencies. In the years that followed, a number of these community agencies chose to move out of this field of activity. Indeed, they considered that they had achieved their goal of ensuring universal access to parole. Others, however, continue to offer this type of service. In this regard, let us recall that in 1971, Minister Jean-Pierre Coyer spoke of a 50-50% sharing between NPFs and NGOs.
Please.
Sure. Well, donc.
So, quickly, in the 1980s, new actors arrived in Quebec, and there was the implementation of direct surveillance as we know it today in Quebec. And quickly, just to tell you that I read the inquiry report, and we believe that the 5 recommendations will improve surveillance in community. The strategy that allowed this person to frequent a massage parlor is something that I hadn't heard of or seen before. Sorry, I know I'm taking too much time, but I would like to conclude by saying that CSC should go beyond the recommendations of the committee, and correctional services removed direct surveillance. That's all I have to say. Thank you.
Again, I apologize for having to do this to people. I don't take any great joy in interrupting. It's some combination of Mr. Stapleton and Mr. Newfield for the next 6 minutes, please.
Thank you. USJE represents all parole officers, program officers, teachers, and other federal correctional employees that work in non-active security functions in Canada's 43 federal prisons, 92 community parole offices and sub-parole offices, 14 community correctional centers, and 4 healing lodges. Of course, the murder of Marlene Lebec was a tragedy, a devastating event, not just for the family of the victim, but for those employees in the correctional system that work each and every day to rehabilitate offenders. Because of an ongoing disciplinary process, respectfully, USJE is not in a position to comment on any of the specifics of the case today, but we will speak to the role of parole officers in federal corrections more generally. At any one time, There are approximately 9,000 offenders under supervision in communities throughout the country who parole officers and case management teams are mandated to supervise. Many people mistakenly believe that parole officers only work in the community, like provincial probation officers. But in fact, the process to safely reintegrate offenders back into the community begins at their assessment by an intake parole officer upon their arrival into a federal institution. Once the federal inmate is assessed for criminal history, security risk, and their potential for rehabilitation, the wheels are already set in motion for their release into the community. Very few offenders enter a federal facility with no prospect of leaving it. And this is equally true of offenders with a history of violent offenses. It is not parole officers who make these rules, but the judges who sentence them. Additionally, it is the Parole Board of Canada who, as you know, is mandated to carefully review an offender's application for parole. It is the Parole Board who imposes the conditions under which offenders are supervised in the community. There is no doubt that federal parole officers who work directly with the offenders while they are incarcerated play a crucial role in making recommendations about the conditions for the offender's release. Ultimately, however, these are just recommendations. That being said, parole officers play a pivotal role in preparing offenders and advancing public safety. Sadly, however, they are not always treated that way. In the case of a violent offender, such as someone who has murdered his or her spouse, you might think that parole officers are given more time to carefully assess the background and circumstances of an offender with a history of committing a homicide. This is not the case. Caseloads are extremely heavy in federal corrections, and no distinctions are made based on complexity or violent past of the offender. You may also think that a parole officer would have clerical support to support the acquisition of crucial court documents that are often hundreds, if not thousands of pages in length. This is not the case either. Many clerical positions were cut by the Correctional Services of Canada in 2016 and have not been reinstated. In fact, parole officers sometimes wait months, if not years, for these documents in certain cases. Privacy considerations prevent the release of material from police agencies and other relevant bodies such as victim services, children's aid, etc. Consequently, many parole officers are left to navigate complex administrative processes to receive relevant information. The requests from parole officers do not receive special consideration. They must get in the queue like other players in the criminal justice system. Unfortunately, they don't always get what they need when they need it. You might also assume that parole officers receive leading edge training on an annual basis that equips them with the best assessment tools and provides a meaningful opportunity to talk with their peers about best practices. This is also not true. In fact, due to cuts, almost all training has been virtual for a number of years and does not always align with what parole officers need. This is something that federal parole officers believe has been a significant detriment to their profession. It is for these and so many other reasons that in 2019, USJE released a groundbreaking report, Protecting Public Safety, the challenges facing federal parole officers in Canada's highly stressed criminal justice system. For this study, USJE invited parole officers from across the country to share their perspectives on the status of the correctional system and their role in it. Hundreds responded, most of whom had never been involved in our union. Overwhelmingly, they said Canada's correctional system is stressed and nearing a breaking point, with a majority of parole officers asserting their working conditions often prevent them from properly assessing, supervising, and preparing offenders for their safe return to society. High offender caseloads, chronic understaffing, and significant changes to correctional programs and services are cited as presenting insurmountable challenges to the managing offenders' risk. More than 2/3, 69% of parole officers surveyed worried they are not able to sufficiently protect the public given their current case workloads. 92% agreed that an increase in staffing would improve their capacity to keep Canadians safe. 85% agreed that a decrease in the number of offenders signed to them would improve public safety. We submit this report in part as part of our testimony today and ask that it be considered as to you for making recommendations. You would think that this report would have been the catalyst for an important dialogue within CSC on how to improve the system. Instead, it fell on deaf ears. USJE has no formal response of the report since the release in June 2019. In conclusion, it is appropriate for the Parliamentary Committee and the Joint Board of Investigation, which has now released the report, to look at what got missed in the case management around the homicide of Marlene Lebec. But without a systems-wide analysis on how to better equip and enable parole officers and the correctional employees that are on the front lines doing the work of supporting the reintegration of offenders each and every day, USJE fears another tragedy is just around the corner.
Thank you, Mr. Stapleton. And just before I ask colleagues to start questions, that report, has been received by the clerk, but not translated, and it will be distributed. So with that, Madame Stubbs, for 6 minutes, please, or 5 minutes, please.
Only I could figure out how to unmute myself. Thank you. Thanks, Mr. Chair. I appreciate that. The testimony that we've just heard is, I think, alarming on a number of reasons, for a number of reasons. Obviously, because it must be part of what went wrong in the murder of Marlene Lebec, but also I think it would be concerning to every Canadian everywhere. So I'd just like to invite Mr. Stapleton to give some more information to this committee, maybe to start sort of where you ended, actually. Are there up 3 or 5 or 10 specific recommendations you would make to us that would help better enable and empower the frontline officers who have such important and challenging work to do?
If it's okay, I'll pass this off to David Neufeld, who is a parole officer. David.
Sure.
Hi there, thank you for that. So in our report that was released in May of 2019, again, that's almost 2 years ago, there were a number of recommendations that were made that we went back to the Correctional Service of Canada and tried to have very serious discussions about, but to date, very little has changed. And it still remains a very large concern of our union and particularly our members. So one of the first things that we talk about is workload, and how that our workloads are not divided or given amongst the staff based on the complexity of the case. Rather, it's simply based on the number of cases that you have. So for example, if you have a very high risk, high needs offender that comes into the institution at the front end of the sentence, you don't get additional time to work with potentially more complex, high needs offenders. In fact, it would be just the same amount of time that you would get for everybody else. So one of the things that we are really saying is that workload really needs to be more than just the numbers, and also the amount of actual time it takes to do proper risk assessment and proper interventions with the offenders. The other thing that we have been calling for as well is in relation to the mental health needs of our offenders. Institutional parole officers repeatedly told us that the mental health of the offenders should be a determining factor for a caseload size. As you can imagine, those individuals who come into our system that require more assistance with their mental health needs requires more time. And ultimately, that's what a lot of parole officers have been telling us, is that more time means that we need to have more parole officers available to do the work. And in fact, that has not changed. And I know that the Correctional Service has been under a lot of pressure for many years to reduce their budgets. And then that goes back to the Deficit Reduction Action Plan. And then also in recent years to really make sure we're trimming everywhere we can to make sure that the budgets are not exceeded. And it's very difficult to do that. Other policy changes as well, such as working with Indigenous offenders, has been extremely challenging. There have been some additional positions created over the years, but as it relates to parole officer work and even in terms of programs, we need to make sure that we're giving the time to those offenders and meeting with them to understand who they are, understand their backgrounds, understand what brought them into their criminal activity, and what is it going to take to ensure that they stay out of crime. it's very, very crucial. Really quickly then, I just want to summarize and just say that for parole officers to do their work properly, they need to be able to have the time to have meaningful interactions with everybody on their caseload. And when we're talking about high complex cases, that means we need to have the time to have those meaningful conversations, to understand their world, to understand that if they were to be released back into the community, what are those conditions that they're going to be released back into? What are those relationships that are going to be important to them and their reintegration back into society? And what supports are they going to have? And I'll just leave my comments from there, and maybe if there might be more questions.
You have about 30 seconds.
Oh, well, I guess I would throw it back to the witnesses then for any more that they would say. I guess I find it a little bit alarming that there have been increases in the budget overall in the last 5 years, but it seems like either it hasn't gone to increasing much needed staff members in order to be able to have the kinds of interactions that you're talking about, or somehow that has been insufficient. But
okay, well, we're going to have to leave it there.
Yeah, thanks.
Thank you, Madame Stubbs. Madame Damoff, 5 minutes, please.
Thank you, Chair, and thank you to all of our witnesses for being here. I'm going to start with USJE. In 2016, you very graciously took me on my first prison tour, and I went to I visited the parole office in Winnipeg, and I can remember very distinctly the manager there talking about the debt reduction action plan and the cuts that had been made. And I said to her, you're far too good at your job because you're managing to still do the good work that you do in spite of the cuts that have been made. And Stan and David, you and I have talked about this, but how critical is it for us to be making investments in the community? I think it's about 6 or 7% of correctional services budget that goes to community to support offenders when they're released. How important is that community support, both for increasing the number of parole officers, but also supports in the community for them once they're released? I think probably David Neufeld, will take that one.
Yeah, so in terms of community resources and managing risk in the community, it's absolutely crucial that we have organizations who we can link with to provide referrals to for our offenders in managing those cognitive deficiencies or those things that trigger their criminal behavior, that they're able to get the help that they need. One of the major cuts that we saw a number of years ago was in relation to that of psychological counseling for offenders in the community. And again, as you can imagine, with high complex cases and needing access to psychological intervention on top of the meaningful contact that should be taking place with not only parole officers, but also with correctional program officers that we have in the community who are delivering programs to these offenders. We also have other needs, such as access to, I would say, residential substance abuse programs. These are things that were cut because as a result of the need to reduce the budget. And these are absolutely crucial pieces to our overall interventions plans, and making sure that when these offenders are being released to the community, they have the supports that they need. Because really, when it comes down to what corrections does, we understand that people have the ability to change and that we have a responsibility and an accountability to managing risk, but we need those resources in place to ensure that no matter how long that particular offender has been in the community, that we're fully aware at what they are doing with their time, making sure they're getting the help that they need, and making sure that if they're living next to you or to me or your friends or your family, that we can be confident that we know what they're doing and how they are using their time, and of course that they're not falling back into their old criminal behavior.
Well, I just want to commend you and all of the parole officers for the fine work that you do. I've spoken to a number of parole officers, and I'm always impressed. And I think I'll start with Mr. Henry, and maybe Mr. Neufeld, you can respond as well. But how important is parole itself to the successful reintegration of offenders? So is it better to keep them in prison till the last day of their sentence and then send them out in the world, or is parole important?
Non, je pense que la libération conditionnelle.
I would say that parole is really an essential measure of social rehabilitation. The fact that we offer parole and the supervision in the community allows us to ensure the safety of our communities. We evaluate the person, we see how the person evolves in the community, and if the person is not organized, if the person doesn't respect the intervention plan, if the person is not involved, well, in these cases we can suspend parole. Parole allows us to protect our communities, and the statistics are clear. A person who is released statistically will reoffend less than a person that has statutory release at the end of their sentence. And they, of course, will reoffend less than those who stay. And as a criminologist, the type which is most concerning are not those who are on parole, but the person who are maintained incarcerated until the end of the sentence, and that after 10, 12, 15 years will reintegrate our communities without any form of supervision or support. And that's a real problem. There are about 50, 100 persons a year that are kept in penitentiary. And when we try to address that problem in the community, we're facing a void because no one wants to fund these services because they're not under the mandate of correctional services anymore. So it's not up to them to pay. Neither public safety, social services don't want to fund them either. So we have people who are going to go to resources of homeless people while whereas they've been incarcerated for 10, 15 years.
There, Madame Demo, I know Mr. Newfield is keen to respond, but you're going to have to work it in some other manner. With that, Madame Michaud, 5 minutes, please.
Thank you, Mr. Chair. Thank you to the witnesses for their presence, and thank you to Mr. Henry. I will take on your invitation as soon as the sanitary situation will allow it. I think it's very important for us to go and see what happens in the ground, and that's going to be very precious for these types of studies. So thank you for telling us more about the various centers and services that are offered. I think it's very important. And you also mentioned it in your conclusion that Correctional Service Canada have announced that supervision of inmates in Maison Pechot will be given to CSC in March 2021, and that they are going to review the nature of the agreement and to cancel it rather than reviewing it, that is, as you've said. And you didn't seem to be in agreement. For what reason? Why would it be better to review the agreement rather than canceling it altogether? Well, as I was trying to show in my introduction, direct supervision is part of a long tradition. So it's not just been yesterday that community organizations participate in the supervision of offenders in the community. CSC needs to be able to count on partners in the community to ensure the safety of community and to ensure social reintegration. However, there are many advantages to direct supervision. For example, you might avoid duplicating some administrative tasks and might be able to know more about the offenders. And for some antisocial offenders, the opposition to their supervision is being reduced by the fact that the workers are not employees of CSC. Sometimes they don't like the staff of CSC, and this way we can also have a diversity in approaches, which might be quite necessary to ensure social integration of individuals. There's not only one single approach that works for all individuals. It's important to adapt to the situation. So it's unfortunate because CSC has decided to go beyond the recommendation of the Board of Inquiries, while we had started to review everything that is in the BOI's report about the roles and responsibilities. Of course, we didn't wait for the report to act concretely on the ground. When such an event occurs, it's all the workers, the clinical counselors of halfway houses, parole officers who question their own practices. And we had clarified at a meeting with the CSC in spring and fall the various responsibilities. So it's quite unfortunate that all this work basically has not been taken or reviewed by the central administration of CSC. Thank you. And usually, you know, in all institutions, I think it takes several cases of failure before we decide to cancel something. And so you said it was probably an isolated case. You had never seen that in all of your career. And, you know, now we have a situation where the agreements are being canceled. Maybe it's a way to discredit also the way things are done in Quebec. We know that, you know, in Quebec things are done differently than elsewhere in Canada, rather than actually targeting those who might have made a wrong decision in this specific case. Do you think that putting the blame on the Maison Pinchot is a, you know, bad excuse to find a solution to this situation? Now, as you've pointed out, I think this is a very specific case. So based on a specific case, it's very difficult to generalize. The Maison Pinchot has been existing for 53 years. 53 years. You can imagine the thousands of individuals who have received support from Maison Pinchot throughout these years. And to my knowledge, in all these years, 53 years, there's one person who committed a murder while staying there, and it's Stachioesi. So it's really a very specific case. So I find it quite unfortunate that, you know, it is being generalized. So since the 80s, this is a model that has proven itself, that a model that's been used in the province of Quebec, and all assessments that had been done by CSC every year of the various organizations that do direct supervision were always very good on the work that was done. So I think it was really a work that was done in partnership, of course, with the staff from CSC and the parole board and the person responsible for parole. But, you know, there were, I mean, if it didn't work, the reoffense rates were much higher than what we have just presented to you.
You showed. Mr. Harris, final 5 minutes, please.
Thank you, Chair, and I thank you to the witnesses. Mr. Either Mr. Sutherland, I'd like to ask a question to the parole officers, because I'm looking at the report that was prepared in May and released in June of 2019, which I did have a copy of. And I know workload is a very important issue. And as you pointed out, Mr. Staples, and in your evidence, 70% of parole officers reported that they don't feel that they can adequately protect the public given the current workload. And as we're dealing here, and I think this is important for anyone listening to this to know, that we have parole officers in the institutions who are assessing the capability of someone for parole, and parole officers in the community as well. So, and you people are perhaps the ones who are assessing the risk more than anyone else in terms of each individual potential for reoffending. And I see that the workload issues, some of them are identified here in responses to questions as staff reductions, lack of resources, parole officer positions being left vacant, insufficient clerical support despite the increased workload, other support positions being left vacant, and cutbacks to funding, all of which speak to an inadequate number of people doing the jobs you do. Yet we hear from the correctional investigator that the ratio of correctional officers to inmates in our prison is higher than it is in almost any other institution that's comparable. Could you square that circle for me? Are we dealing with a misallocation of resources? Are we dealing with a lack of spending the money in the right place, or are we dealing with a lack of money altogether?
Well, go ahead.
You go, Dave.
If I just could quickly comment on that, as Ms. Damoff had indicated earlier, about 6 to 7% of the overall Correctional Service of Canada budget is spent in the community, and the vast majority is spent on structure of the institutions and, of course, dynamic security. And I think it's very important to understand that how much money we invest in reintegration is absolutely important. And I think that in terms of overall work in the Correctional Service of Canada, I would say every employee plays a very practical and important role in the reintegration of offenders. But it's very important to understand that if you're not investing in the community at the same time, that's where the rubber meets the road. The offender, if he's living or she is living inside the institution, it's not life on the outside. And it's important to understand that anybody can do time. I don't know if you've ever heard of that saying, anybody can do time. It can be very hard time, but it's when you come into the community and you have to now live again and have a bank account and work and support your family perhaps, or whoever's part of your life, there's always problems. And so if you don't put resources in the right place, it's absolutely an issue. And I really do believe that CSC needs to take a look at how much money it's investing in the community. The institutions are absolutely important, but there needs to be more money invested in terms of how we're doing supervision in the community. I'll turn it over to Stan.
Well, I can just add, but one of the parole officers replied to the survey by saying, I don't have enough time to see my offenders on my caseload and write reports. It's important to meet regularly with offenders so you gain a better understanding of the person you are working with. The workload doesn't allow for that. That seems to say it all, Mr. Neufeld, in terms of the consequences of an inadequate level of support for community service for the parole officers and the community risk. Rather than going to Mr. Stapleton on that point, I would like to raise another point that is raised in your report, because it has to do with the lack of resources for assessing offender risk. And speaking of offenders, for example, the CSC methodology for assessing risk ends up with their overrepresentation of certain offenders, primary, indigenous, and higher levels of security classification, and that affects their ability to get effective program or opportunities while serving time. That's been pointed out by a recent Globe and Mail article in these recent days. And you say that too many offenders don't qualify for programs and actually need one. So again, in terms of assessing the risk and the ability of someone to be able to operate in the community, they do have to have access to programs within the institution as well. Would either you or Mr. Stapleton care to comment on that problem, the lack of actual programs availability in the institution for people to prepare themselves to be able to live?
I think that's a very important question, but Mr. Harris unfortunately has not left you any time to answer the question. However, we do have a minute or two left, and I would appreciate an answer to the question. If I can get it within a minute of one or both of you, that would be even better.
Okay, I will take a stab at this one. Firstly, I want to make sure it's clear that within the prisons, correctional officers, we don't represent them. We represent the program people and parole officers and that. And within the prison system, one of the problems that we had in the past when offenders came in is they had to wait to enter into a program. With the integrated correctional program module, which I don't think is as good as the old system, they're able to get the offenders into a program right away. So your short timers will have some programming before they get out. Unfortunately, people that are doing medium term, they take these programs, and it is our opinion, my opinion, based on responses from program officers across the country, that this program is not as effective as the old programs that we used to have, that were really focused on the individual problems that the offenders needed. And of course, in order to deliver as many programs as we need for all the offenders, we do need to increase our program staff and the program capability that we have within the prison system.
Thank you, Mr. Stapleton. Unfortunately, we're going to have to leave it all there. We have a meeting coming in behind us, a virtual meeting coming in behind us, and so the clerks need a chance to get things organized here. On behalf of the committee, I do want to thank you for your time and your patience and your cooperation. This has been a very difficult study, and we appreciate all the efforts that all three of you put in on a daily basis to make the public safety of Canada that much stronger. So thank you for that, and on behalf of the committee, thank you for your appearance here today. Colleagues, with that, we'll call an adjournment. Unless things change, I don't anticipate a meeting on Wednesday. And maybe we could do some offline discussions as to what needs to happen after that. So with that, unless my clerk says otherwise, meeting is adjourned.